Okay. Yeti microphone. Okay, that should be working now. Just let me know in the chat. Thanks, Sherry, for letting me know that you couldn't hear me there. I'll redo my intro. Just okay, perfect. Yeah. Okay, something reset the whole. I didn't realize that the mic wasn't working. I should have done a test. The app that I use all reset today, so I had to like get the cameras working again. All the preset things were off. Okay, let's start over. Let's start straight from the top. I get to do a better version of it this time. Welcome tonight. I'm David Brannon. I'm your friendly neighborhood lawyer. We're going to talk today to answer your questions about employment and disability law. I was saying when you couldn't hear me that I'm very thankful for all the people that are sending in questions in advance. We've got a lot of preloaded up questions. I really enjoy that because it gives me some time to think over some of these questions and how I might answer them rather than trying to always answer them on the fly. That being said, please put your questions in the chat if you also have questions. We'll answer those too. In addition to answering the questions, I have two prepared topics for tonight. We'll start by talking briefly about the going to a Social Security Disability Tribunal hearing. That's for CPP disability. I've done a lot of these hearings, probably close to 100 or more at this point. I have to think that it's getting, I haven't added them up, but that is probably in the range. So I've done a lot of these hearings, and I have some thoughts on how you can prepare and to do a better job. Second part, the second part that I was going to cover tonight, in addition to all the questions, is going to be the issue of working part-time while on long-term disability, the pros, the cons, how you should approach it, and we'll touch on that too. Apart from that, what I did tonight, rather than go to the Canadian Disability Forum, I've just I went on there and grabbed some questions that people have posted recently, and I've just loaded those in so we can just I'll just put those questions up on the screen and we'll answer them. And then I'll go on and let those people know that I've answered their questions here on the stream if they want to go check it out. Okay, with that said, let's dive in. And certainly if you have any questions, just put them in the chat. Let's start with talking. Whoops, that's not the one I want. Oh, I see what I did. Just a sec. Hold on, folks. Hold on. Got too much going on here. There we go. We're going to start with tribunal hearings. Okay, so I've been at this a few years now, to say the least, and I'm going to be 52 this year, so I've been doing this lawyering thing for a while. I've done a lot of CPP disability. I'm sure there's people in Canada who've done more hearings and CPP disability than me, but I would put myself into the upper group of people that have done a lot of these hearings. It's a big part of my practice, and I've continued to do these cases over time, and I continue to do them. Perhaps not as many as I used to do, but I still do. I'm regularly working every week on CPP disability claims, and I have 1 to 2 hearings a month is usually what I average. So let's talk about how we prepare. So I prepare clients in a certain way, but this would apply if you are preparing yourself to go and do one of these hearings. One of the most important things to keep in mind with a tribunal hearing is it is a presentation, and the person there who's the decision maker is going to be the tribunal member. I often refer to them as the tribunal judge. They're technically not a judge, but they fill the role of a judge. The tribunal, the Social Security Tribunal, is just a special type of court that has been constructed to only handle CPP disability EI type claims. And whenever you're going before a court, it's very important to understand what is the decision maker looking for. You're going before this court and you're asking them to approve your claim. You need to think ahead of time, what do I need to do to maximize the chances that this judge will approve my claim? That is kind of the mindset that you need to go in with. That's really what it's all about. It's all about, what do I need to give them to help them approve my claim, if they're inclined to do so? Even if maybe they're inclined not to do so, like, what do I have to do to overcome that and give them the opportunity to approve my claim? Well, the first thing I would say is you would never want to go into a tribunal hearing without having given them written submissions in advance. Written submissions would be a brief. Sometimes it's called a trial brief. You would want to give them an overview, a written overview in advance of your situation and the legal arguments for why they should approve your claim. Very important to do that. I've had situations where we got hired late, and so we weren't able to put a brief in because there is a deadline. And the judge made specific mention of it, of being disappointed there wasn't a brief. I had to clarify, look, we came in late. We weren't able to get a brief in. So I've had judges tell me specifically they would like these briefs in advance. The brief is meant to give them an overview and help them digest all the information. With some of these cases to the Social Security Tribunal, there can be 1,000 pages of documents. And so it is very helpful for them to have someone have synthesized it ahead of time, pointed out all the important parts to make their job easier. Ultimately, you want to make their job easier and easier for them to decide in your favor. And part of doing that is pointing out ahead of time all of the important things in a brief. So the first thing to know about doing a hearing is it's not all about the hearing. I would say 75% of it, maybe even 80% of it, is the brief and the information you get in ahead of time. Okay. Now, once you get to the hearing, the way these hearings work is they are scheduled for about an hour and a half, which is not long, by the way, considering some court trials go on for weeks. It's an hour and a half. Think that's not a long time. However, it's enough time for the context of what you need to cover. But you have an hour and a half, and about 10 minutes of that will be spent by the judge in the beginning, just explaining what's going on, making sure everything's working. So already you're down to like just over an hour to do your case. And so that's the first thing to keep in mind. Now, the way it works, I've only ever been to these hearings where I'm representing someone. So when I show up with a client, the judge will say, okay, I'm going to turn it over to you to let me know why. And I assume they would do the same thing if you were there representing yourself. They will turn it over to you to say, okay, it's your chance to now give me your presentation on why you feel that I should be approving your case, or why you think that this court should approve your case. And so when it's turned over to me, I always start with an opening statement where I give a summary of the theme of my case. I don't call it the theme, but basically the theme of the case, and maybe the big overview of why I think we should win. Okay. Then I get into what's called a direct examination. That's where I interview my client. It's called a direct examination. You've seen it on TV with court shows where the lawyer is questioning their own client on the witness stand. That is what we do. So I go back and forth with the client, and that is how the client gets out their evidence at the tribunal hearing. Now, it's good to do it when you have someone. It's harder probably on your own to come up. You'd have to come up with a monologue that you would deliver, which is fine. I would encourage you to write it down and have your key points so that you kind of stay on track rather than just going in there and riffing off the top of your head. It's more likely to be rambling and unfocused. You want to be very focused. So that is basically how it goes. So I take my client through all of their evidence, their testimony, and that takes the majority. That's the majority of the time. I leave about 10 minutes at the end, at least, to do a closing argument. And that's where I do the final closing argument for why this tribunal should approve the case. Things that are very important when doing your presentation: it is critical that you focus on what is important to the tribunal member. The biggest things for them are going to be the idea that there's a few things. Number one, they want to know that you did everything possible to stay in the workforce. So I will spend a lot of time with my clients going over all the reasons and ways they tried to stay in the workforce and get into a lot of detail there. Often it's hard to get that detail into the brief because a lot of this detail has to come from verbal testimony, and it's just easier to have the client explain it all. So I'll spend a lot of time on that, a lot of time. The other thing you'll want to do is it's very important to identify any red flags around the idea that you didn't do all the medical treatment that was recommended, or that you didn't comply with medical advice. Anything around that will be a death sentence for your case. If the judge decides that you didn't do everything you were medically supposed to do, or you but didn't follow medical advice, you will basically lose the case 9 times out of 10. So it's important for you to find any inclinations any information that says that, including sometimes the ministers, like the Service Canada, they call it the minister, but because it's I don't know why they call it I know why they call it the minister, but it's just a very weird word. The minister just refers to the government and their submissions. They will have submitted. The government won't be at your hearing. I should have said that up front. The government won't be at the hearing, but they will have sent in their own written submissions. They will often point out areas where and will allege that you did not do everything medically that was asked. The good thing is you will have that ahead of time, so you should be addressing any points they raise that you didn't follow all medical advice. You have to address those head on, because if you leave those unanswered and the judge accepts them, then you're toast. So you have to spend a lot of time identifying all the red flags around maybe you didn't do everything medically you should have, and answer those in detail for the judge. That includes things the minister identifies. It might be things that they didn't identify that maybe the judge noticed. Now, the judge, if you don't address them, oftentimes the judge will bring it up themselves to you and give you a chance. It's just better if you can anticipate ahead of time which these are all going to be, so you can better prepare to answer them. Another good thing that you can do with tribunal hearings is it's a great opportunity for you to give a lot of detail on your functional limitations. These are restrictions that you have doing daily activities, either mental restrictions, physical restrictions. You can get into a lot of detail, give examples. That is very helpful for the judge, especially if you're trying to establish a pattern that maybe you can do work sporadically, but it's not because the nature of your symptoms, you can't do them every day. Like, the more details you can give, the better. I often get I like to give specific examples. So I will prepare my clients ahead of time to say, like, give some examples of when you did try to put yourself out there and do something that would push your limits and it kind of blew up in your face. Like, you tried to attend a wedding, you tried to go to a hockey game, you tried to go to a movie, something where you had to sit somewhere for a long time or do something out of your comfort zone. It's better to be able to give a specific example on a specific day. Like, oh yeah, I went to my cousin's wedding last summer, sometime in August, and this is what happened when I tried to stay there the whole time. Like, it's more credible if you can give real life examples of when you tried to put yourself out there and were not capable of doing it. The reason you want these kinds of stories is because oftentimes, you may not have tried to return to work for a year or two or more by the time of this hearing. And the judge may say, well, how do you know you can't work now if you haven't tried to go back to work recently? A good way to do that is to give one of these examples of a recent time where you kind of put yourself out there to do kind of physical exertion or mental exertion that would be similar to what would happen in a workplace, and show how it did not go well for you. That is a good example of how you can give better examples and help the judge understand your situation. So I've covered, those are some of the big ones there. Other things would just be filling in gaps. Very useful to spend your hearing filling in gaps of information around your work history, failed work attempts, treatment. A lot of things I've already covered. There may be contradictions in statements or in the forms. Like, a common contradiction is maybe one form you said you felt you could no longer work as of this date, but there's another mention somewhere else of a different date. Like, this is a perfect chance to be able to explain and reconcile things. Now, perhaps the most important thing, just from an effectiveness point of view, is you really have to have your presentation be structured so that it is easy for the judge to follow, easy for them to pay attention and digest what you're saying. This is extremely important. One of the biggest dangers you can get into, and you're more susceptible to this if you're just representing yourself because you won't have anyone there to kind of put the brakes on, is you can't just go on a long, unstructured speech. It's too hard to follow. It will meander around. You're covering different topics. It's very difficult. So a very effective way to do a better presentation is to use something called signposts. So what you would do is you would break up your presentation into different topics. And at the start of each topic, you would say, now we're going to talk about this topic. And then you talk about that topic. And then at the end, you say, okay, we're done talking about this topic. Now we're going to move on to this new topic. And that's how you do it. So I tell clients this in ahead of time. I developed this because I had a few bad experiences with clients who got mad at me, actually. One of them got really mad at me because I kept cutting her off during the hearing. But I was saying, look, I have to cut. I told her afterwards, I had to cut you off or we were going to run out of time. And you were talking about things that were not important, if I'm going to be frank. So she really got insulted by that. I will say her case got approved. So the cutting her off, I think, was quite important to do to get all the information that we needed. But I learned after that I have to prepare clients ahead of time so they're not caught off guard if I cut them off. By cut off, I mean just say, interrupting them, saying, look, we have to move on to this next topic. You're moving off the topic we should be covering right now. And so I became better to help prepare clients. So I will tell clients in advance, we're going to do topics. I'm going to ask you questions within the topic. If you start to stray outside of the topic, I'll point it out to you and we'll come back on topic. Otherwise, it's going to be very difficult for the judge to follow what we're saying, to pay attention. They'll start nodding off. It's very hard for them to process it if you're jumping around different topics. It's also easier too. A lot of the judges will go back and listen to the transcript afterwards before making their decision. And if you've kept everything in topics, it's very logical and easy for them to navigate and find. It's all about making their job easier. That will make it easier for them to go back and review it as well. So that is a thing that you should really focus on, topics. And for example, some of the topics I might use would be, I commonly start out with saying, okay, we're going to first start with your work history, your education and work history leading up to the time you stop work. Then I'll take the client through it. If they start talking about medical problems, I'll say, we're going to cover that in the next topic. But for now, let's just only focus on your work history and your education. And by setting that up, it also allows the judge to know why I'm interrupting my own client and trying to stay on topic. And the judges appreciate it. Even though they don't tell me, I know they must appreciate it because they're not telling me to stop. So then at the end, what I'll often do is ask the judge if they have questions on the topic, and they can put their questions in as well at that time. Because the judges will ask you questions during the hearing. That's normal. And I say, do you have any questions on this topic? And sometimes the judge will just jump in and ask them. Then you move on to the next topic. And the next topic might be let's talk about your medical condition in the year of the minimum qualifying period, right up till December. Let's talk about how you were doing that year. Very important. What will happen is we start talking about, let's just say that year was 2020 or 2021. We'll start talking about it and clients will shift naturally to start talking about the here and now. And I'll have to say, wait, remember, we're talking about back in 2021 and it's important we focus on that. So this is where you have to keep, otherwise you're mixing back in 2021 till now. With CPP disability cases, it's critical to establish your disability started in the last year of your minimum qualifying period. And for example, if it was 2021, it is extremely important that you give very detailed evidence related to how you were doing that year. You can't intermingle that or confuse it with how you're doing now or things that happened since then. Okay. I think that's pretty much what I will say there. It's very, if you start from the point of view of these hearings, what can I do to make the judge's life easier and so that they can pay attention and allow them to check off all the boxes. They can't approve a case where they will not be able to approve any disability case where the person did not use all reasonable efforts to stay in the workforce. So I need to give them a lot of information that they're able to put in their decision to show that I am the person that did do a lot, okay, to stay in the workforce. They cannot approve a case where someone did not follow medical advice. So I need to address all these points that make it look like I didn't follow medical advice and explain that I did follow, or if I didn't follow, I had a legally justifiable reason not to. And so that way they can check off that box and they would be able to approve the claim without getting criticized by other judges or having their case overturned. No judge wants to be criticized or have their decision overturned at the next level. So you have to give them the information they need in order to be able to approve your case. You can't just ask them to approve your case if there's this information that you didn't follow medical advice and you've given them no evidence or reasons why that they could rely on in their decision. You're asking them to do the impossible. They just won't be able to approve it. And yeah, that's pretty much it. So I encourage you to, if you have one of these hearings, I would encourage you really to consider getting a representative. And it's easier to do a hearing like this when you have a representative. Even if you're a lawyer, like judges routinely will make comments for lawyers who try to represent themselves in court. There's the old adage that a lawyer who represents himself has a fool for a client. It is the reason why they don't want lawyers representing family members. You're not objective. You're not objective representing yourself. It is better to have someone else helping you with a hearing like this. If I had to do a hearing, I would get a lawyer or representative to work with me, even though I've done a million of these. Why? Because it's too easy to get tunnel vision and wrapped up in things emotionally when it's your case. Okay. See if we got some questions here. All right, we got a question, so let's dive in to some questions. We got one here from B Cheating Pinoy. Out of topic question here. If I am receiving LTD and there will be a human rights complaint mediation, are the possible settlement money deducted or clawed back from my LTD insurer? Okay, yes, very good question. So this is someone who's on LTD. They've got a human rights case. They're wondering if money gets awarded at the Human Rights Tribunal, would that money be deductible from their LTD? The starting point, whenever you have a situation where you're wondering what money gets deducted, the starting point is always the LTD policy or booklet itself. Each of these policies or LTD programs are different, and they have unique wording around what they're allowed to deduct. But they're only allowed to deduct what the policy says they're allowed to deduct. And again, like these policies, they're not all the same. They're worded differently. So you have to read your specific policy and read through what you're allowed to deduct and see if they're allowed to deduct any type of damages payable through a tribunal hearing. Now, what I would tell you is that, because I do represent people at human rights tribunals. That's a big part of my practice as well. And the type of money you can get paid out of a tribunal, there's two types of money that can be paid. There's money that can be paid that represents loss of income. And there's money that can be paid that represents basically pain and suffering type money. So money for injury to dignity and things like that. Okay. Now, money paid for injury to dignity is almost never deductible from something like LTD or even from like severance. It's not taxable as income. So that type of money is almost never deductible. I say almost never. But money that's designated as like loss of income can be deductible. So you have to be careful, like how the settlement that you reach at the Human Rights Tribunal, how is the money characterized? So it's very important at a hearing like that. Maybe it has to be legal and reasonable, but sometimes it's better to say that, okay, there's this $20,000 this is all for, there's no loss of income. It's all for injury to dignity, self-worth, and self-respect. Okay. So that would be, if it was characterized as that, it would be more likely that it would not be taxable, first of all, and it is income, and it's more likely not to be deductible from things. However, if you're at a hearing at a hearing and you get money and it is designated as income loss that resulted from the discrimination, then that money is taxable as income, first of all, and it would also have a greater likelihood to be deductible from LTD. So good chance that if you're on LTD, there's a decent chance maybe that you don't have a loss of income claim. So it would mostly just be money for injury to dignity, self-worth. And that's something you want to keep in mind. All right. Hopefully that answers your question. Midnight says hi. Hey, Midnight Blue. Question is, I'm coming up on 1 year LTD for mental health. Is it better to not try a return to work with a good chance of failing? My doctor said it's up to me. I suffer from schizoaffective disorder. Okay. I guess what I would say is it's always from the lawyer's point of view, I always go on the side of telling people to try a return to work if you think there's some chance. It's always better for you in the long run to have tried and failed to go back to work than to never have tried and have everyone say that maybe you could have gotten back. That being said, like, you have to be in a situation where it's reasonable and your symptoms are stable enough that you could try a return to work. Now, what I would say, Midnight Blue, is that most insurance policies, they do allow you a period to try to go back to work. And if it fails, you go back on the same claim. So you don't have to start over. Most group long-term disability policies have like often a 6-month window where if you try to return to work and you go back off again because of the illness worsened or whatever, then it's the same claim. You don't start over with a whole new claim. That's something to keep in mind. You'd want to read your policy to find out like exactly how it's worded for you. But this is really a tough decision. It's something you'd want to decide with your doctor on whether you're well enough to try a return to work at the 1 year point. But I certainly encourage people to do it if you think there's some chance, because it will strengthen your case. Trying a return to work and having it fail can be demoralizing, but it does take a lot of wind out of the sails of the insurance company saying that you didn't try hard enough and that type of thing. Just like I talked about for the CPP disability claim, a lot of what the judges want to see is that you made a lot of efforts to try to return to work. And the more false starts and tries to go back that failed, the better to have a long-term disability or a CPP disability claim approved over the long run. All right. Let's dive into some questions that I had sent in advance. And I'll keep my eye out for those of you posting as well. Oh, we'll just follow up one more time with Midnight Blue here. So Midnight Blue is saying, my med is stable, but I have some symptoms, psychosis. My psychiatrist said it may help. My insurance is not asking me to go back, but I want to have a Nona. Maybe that means a note. A normal routine in life. So I guess I'm putting pressure on myself. Okay, yeah. Well, look, if your psychiatrist is saying it may help to try to get back to work, that is something that I would want to do. But if you're still having some psychosis, it makes it very difficult, depending on how intrusive it is and how well you're able to deal with it. So definitely getting back to a normal routine is very helpful. So this is just something to really talk with the psychiatrist. I would really stress that you want to make sure, like, continue to try to work and get the psychosis under control as much as you can. Going back to work is going to be very stressful. So it will, if you are going to be in a situation where a lot of adding stress is going to cause you to go get symptoms to get worse, that is something for you and the doctor to be ready for. And I would say that if you were to try to go back to work, you would want to be under close monitoring by your psychiatrist. And if things are starting to go downhill, that you stop the return to work quickly so that you don't have a crash and burn type of situation. And you don't want to damage like your relationship up in the workplace and things like that. So it's a delicate situation. I would work closely with the psychiatrist. And if you think that you're stable enough that adding the stress of a return to work, maybe it won't be that stressful for you. I'm assuming it might be, but if it's not, then it certainly is helpful to get back to a good routine. But I'm just keep in mind that if you were to try and it didn't work out, almost certainly your policy will allow you to go back on benefits because it's called a recurrence of disability. So if you go off again, it's usually within 6 months. You'd have to read your policy to see how long it would allow, but that's basically what we'd be looking at there. All right, let's take a look at some questions here. We got some very detailed questions, so I'm going to do my best to answer them. All right, let me go grab them. This first one is around pregnancy, maternity leave. And it says, if someone has been on LTD for years and then becomes pregnant, can they still receive their employer's maternity leave top-up for full-time staff? Good question. A lot of places of employment do have top-ups for maternity. And this person's wondering, look, my LTD is not paying my full income. And if it doesn't have inflation increases, then it's really like it's my income from years ago, so it's very low. Can I get a top up through my employer's plan? The answer is probably no, but again, I can never say for certain without knowing your situation. But pregnancy leave and LTD benefits are separate things completely. If someone is already on an LTD plan, and if you're already on LTD, the payments continue during the pregnancy, even though you're pregnant, your LTD payments will continue. But the maternity leave payments, they are meant to be a salary top up that is different than the LTD. It's usually these types of maternity benefits, paternity benefits. They'll talk about you have to be an active employee in order to access them. But again, you have to read what your own policy says. But typically, you have to be actively employed and going on a maternity or parental leave. In your case on LTD, you're already on a disability leave. So you're already on a leave. That probably would disqualify that. The fact that you're not an active employee would probably disqualify you from doing the maternity benefit. But you'd have to see the wording of your policy, of the workplace. It's not an insurance policy, but the workplace, whatever describes the workplace benefits around getting the maternity leave, how it's worded. My guess, though, it will exclude you. The other thing, sometimes these workplace maternity leaves and things, they're meant to revolve around what you can also get through Service Canada EI, so EI maternity. If you've been off on LTD for a number of years, you wouldn't qualify for the EI maternity because you wouldn't have the hours. You have to have recent hours worked. You wouldn't have the recent hours worked. So that would also be probably an issue. But it's certainly possible, but I would be doubtful that it would. But you could look into it. You'd want to get the wording around the maternity benefit and just look for the criteria and see if you fit the criteria or if it does require someone to be actively at work and to leave active work and go on that leave. All right. Okay, let's look at this one. This person had a question that said, what can you do if your LTD insurer suddenly claims your benefits end at age 60, even though all booklets, letters, and past communications said 65? And the employer won't confirm the real coverage. Yikes. Okay, so this is actually something that happens. This person has basically got caught like the old switcheroo. They thought their benefits were going to continue to age 65, but out of the blue, they get a letter from the insurer saying, oh, by the way, your benefits don't go to age 65. They're actually stopping at age 60. So this obviously caught this person off guard. They're confused because they're looking through all their materials and things, and everything talks about age 65. Age 65 is a very common age for benefits to go. But in the fine print, and this, I can't say that's what's happening here for sure, but what I anticipate for this type of case is that in the fine print of this policy, it does, I'm sure it says age 65 everywhere, but there are fine print areas in policies where they talk about when benefits will end. And what I would expect is in that section, it says it will list a bunch of reasons why it will end. It will say you reach age 65, benefits will end if you die, benefits will end if you go back to work, and then it will say benefits will end when you become eligible for an unreduced pension. That could be what's going on here. I mean, it could be two things. Some LTD policies do only go to age 60. That would be rare. Usually when you see a policy ending at age 60, it's because you're eligible for an unreduced pension through like a workplace pension at age 60. And that's generally the reason you'll see this happening. I don't know if that person is listening. I assume they might be because they submitted this question. But if you're that person and you want to give me some clarifications here, that would help. But I expect that this is a situation where there's an unreduced pension, and that's how they're doing it. Now, when you're saying all the booklets and everything, like you have to make sure, if you've been on LTD for a number of years, you have to make sure you're looking at the right booklet and policy. You have to get the policy and booklet that was in force, like the one that was active at the time when you did your claim, when you started and filed your claim. What can happen is you can get later versions and those don't apply to you because the one that applies to you. So when you like, you can be in an employer and they can get different versions of, like, every year they could get a different LTD plan in theory. Doesn't usually happen, but that could happen. There could be like 10 versions over 10 years. The one that will apply to you is the one that was the year when you had your disability claim. That one will stick with you forever. Okay. There might be 9 other ones in the next 9 years. Yours will be always the one that was in place the moment that you applied, when you applied for your long-term disability. Not when you applied, but when you became disabled. All right. You might apply 2 years later, but they'll go back and see what was the one in place at the time when you became disabled. That's the policy that will apply to you. So you'd have to make sure you were looking at the right policy. Then I would be, if it were me, I'd be scanning along, looking around. Is there a section in here where it says when benefits will end? And is it talking about unreduced pensions and that kind of thing? I assume that's what's going on here. Now, let me take a peek and see if that person is. Okay. So a person is, I think someone is saying here, where would you get a copy of the master policy? Very hard to get the master policy, almost impossible. But you don't necessarily need the master policy. Usually this will just be in the benefits booklet that they have. They are required to give, not all provinces are required to give out the master policy, but they are supposed to give a benefits booklet that will list all the key areas, including this. Most benefits booklets are going to have this list of things when benefits end. Ultimately, you can only get the master policy from the insurer itself, and it's very hard to get it from them unless you're in litigation. There are some provinces where it is possible to get the master policy. I got it because it's written in the actual Insurance Act, and I'm drawing a blank. I think it might be Ontario and Alberta, if I'm not mistaken, but that's something I'd have to double check on. Now, if you're not in a litigation with the insurer, you could. So if you're not in a litigation with the insurer, you could file a complaint with whoever your insurer is. They will have an ombudsman. If you're not getting sufficient answers, like, you should be asking them to show you where in the policy does it say that benefits end at 60. Like, you should just get them to point blank tell you, quote the policy, show me where it is, give me a copy of it. If they're not doing that, that is a thing where you could put a complaint into the ombudsman that handles your insurance company. Each insurance company has their own internal ombudsman. If you Google it, just Google ombudsman, name of your insurance company, and it will usually come up. You could contact them for an issue like this, where it's asking for information, and the ombudsman may be able to help resolve that type of situation. But that is what you need to do. Okay, so this may be the person that put in that question. It says, I recently received a letter that my benefits end at age 60. The correspondence that I have from the insurance company from when I was approved and after the change of definition date. Yeah, the thing is, Chris, is that oftentimes the insurers will just send out these letters. So when you got approved, you probably have a letter when you got approved that says you're approved to age 65. But what happens is they just use like template letters that are 99% of the time they're going to be correct. But in your case, the letter was technically incorrect. They probably weren't thinking about your unreduced pension. Probably on its face, your policy does go to age 65 unless you have a pension, unless you can get qualify for an unreduced pension. And I think that's probably what's going on in your case. I think that's probably what's going on. But that's where I would start. So I would start with writing to the insurer. Just ask them, like, can they please just show you where this is coming from, that it goes to age, stops at age 60? Like, what is the basis of it? They should point out the section of the policy and quote it for you. If they don't do that, get Google like ombudsman, name of your insurance company, and then go through that route, and that will help you get it sorted out. Okay, let's go back to Midnight Blue, following up again. So for the return to work, is it better if I say I can't continue the return to work, or can I wait and see if my employer complains about my performance? No, I wouldn't wait for the employer to complain. I would definitely follow very closely with your doctor and have your doctor pull you off the work if necessary. So how it would work is maybe you don't get in to see your psychiatrist, like you can't get in at the drop of a hat, but you would want to have your family doctor maybe being more closely involved here if possible, or have the psychiatrist give you specific instructions, like if you start to get these types of symptoms or this happens, then you should stop work immediately, type of thing. I wouldn't wait for problems with the employer, because that can result in you getting fired or different things. You'd also want to, ideally, you'd want, like in a situation, I always recommend, if you are thinking this, you should ask your LTD insurer, do they have a return to work coordinator who could help put this together? And if you have a return to work coordinator, even if they're paid by the insurance company, I find it is still better for trying to coordinate a return to work like this. And if things start to go poorly, you can deal with the return to work coordinator, and they will often say, yeah, I agree, you should stop work right now, pending your visit with your psychiatrist, if you can only get in within, a few weeks or something like that. All righty. Let's go back to our questions. Okay, this is a very interesting bunch of questions that someone sent in. I'll do my best. Hopefully the person's watching, and if I don't cover everything, then because I think there were quite extensive questions on this. So the question basically revolves around this: does selling art or doing small creative work count as work for LTD? What hours count as part-time? What questions can insurers ask? And how do you handle repeated forms and errors by the insurer? So let's start with the first part around what counts as work. So there's no magic number about what counts as work in terms of part-time. The insurers look at function, not hours. So like even 2 hours a week could be misinterpreted if it looks like you're doing real work. But small creative work, like selling art online, it's usually not evidence that you have work capacity to do full-time work. What I would say is if you're going to do any type of activity like this, where you're going to do small crafts and things, I would be very upfront with the insurer about it. Like I've had several cases involving this exact thing where the insurer will try to blow it up as a bigger thing than it is. Okay. They will make it, and they will take a dimmer view of it and not give you any benefit of the doubt if they discover it themselves. And it looks like you're doing all these online sales and things like that. So you're better off to disclose it up front and just be honest with them about how much you're able to do, how much. Usually people are not earning much money, if any, when you take materials in and all these things. So that is how I would approach it. What they're looking for, they understand, insurers understand, courts understand that people, if you have a disability, it does not mean you are not allowed to do anything. Depending on the type of job you had, there might be quite a bit of this type of activity that you can do and still fall below what your insurance policy defines as totally disabled from any occupation. Now, again, that will be very relative to your policy. So you have to be careful. In some cases, maybe it's easier for you to show that you fall outside of that definition if you're consistently doing and work sales and time spent and that kind of thing. They don't just they look at the time spent. The time spent is probably more important than money. They don't care so much about the money. They want to know, are you demonstrating a capacity for working? Because you could be volunteering and not getting paid anything. But if you're volunteering and doing sustained regular work, unpaid work, that's still evidence of a work capacity. So that is, that is something that you want to take care, be very mindful of. It's hard for me to know exactly because I don't know your exact situation, but it's much better to be upfront with the insurer about what you're doing, to be honest. Now, you're saying that there are errors that the insurers are making. I'm going to go back to your original question here. Now, okay, so you're asking if the insurer starts questioning you about it, do you have to justify how you're able? I think you would give them details about how you're able to pull it off and do the work. It is like you are required to give information about what your work capacity is. There'd be no reason to be defensive about it. I think you would try to tell them how you're able to do it, what's going on. Even if you think that they might try to use it against you, I would still be upfront with them about the small amount of work that you're able to do. Now, there was another part of this where you're saying if the insurance company makes an error on a claim, such as misclassifying a medical condition as pre-existing, what can the claimant do to get the insurer to clearly respond and correct the mistake? Well, that's a tough one because they may not agree with you that they've made an error, and sometimes it's of no consequence. Now, sometimes it is of a consequence, but often it may not be of any consequence either way. If they've approved your claim, then it's not really an issue. But the answer is there's not really anything you can do to make them correct it if they don't want to, for whatever reason. If they don't want to, just because they don't want to put any attention on it, or they maybe they disagree, maybe they're just indifferent, there's nothing you can do to force them. The only way is like in the context of a litigation where a third party would be making decisions. That is the only place that you would be able to get it definitely corrected if in fact you are right. Okay, it's possible maybe that it is a pre-existing condition. You don't view it that way, but maybe that's how it would be decided by an objective third person looking at this and that kind of thing. So the problem is this comes up a lot. People want to know, like, the insurer said this, the IME doctor said this, it's not right. First, you have to look at, like, is it an opinion or is it factual? And the closer it is to like a fact that no one would dispute, it's easier, like your birthday. That's easy to get corrected. The closer it is from that to some type of opinion or assessment, it's harder to get them to correct it if they don't agree and want to. All right. There was another part to this. It says, is there anything a claimant can do to force an insurer to reevaluate the file or issue an amended claim letter fixing an error? No, not really. There isn't. Again, they may not care. They may disagree that they don't agree it's an error. They may be indifferent and don't want to bother. So you can't really get the insurance company to do anything they don't want to do. The only recourse you have is if they stop paying benefits, you can appeal. And if they don't approve it on appeal, you can sue them in most cases, right? So those are what you have as tools that you can use to compel insurance company behavior. But short of that, there's nothing you can do. A lot of these cases, like sometimes another tool that you can use is the ombudsman, but I would be very wary. I would not recommend people use the ombudsman unless it's something of great consequence. Again, I'm not sure. Maybe these are of great consequence. I don't want to like diminish that there's errors and things like that. But sometimes the errors are of no real consequence in this big scheme of things. But again, I don't know the facts of your situation. All right. And there's another part to this that says, can the claimant refuse to fill out the same? This is all from the same person, so I'm just going through it. Can the claimant refuse to fill out the same medical forms repeatedly, especially if the policy says the insurer should contact the doctor directly for additional information? First of all, I have not really seen policies that says the insurer should contact the doctor directly. It might say they have the option to, but I usually it doesn't even say that. So I don't know where that's coming from. Maybe that is in your policy, but that would be unusual. Can they repeat? Yes, they can ask you to fill out the same forms repeatedly. Yes, they can. You have to see what your policy says. Ultimately, your policy, what you're required to do is going to be dictated by your policy. Some policies are very specific about people filling out forms. Some are more general. Even in the most general situation, the understanding for insurance would be that as the insurance claimant, you have an obligation to provide proof of claim, reasonable proof of claim, and that filling out these forms would be part of the proof of claim. And whether the forms became excessive or not, that is a judgment call that, again, a third party could make a decision on. By third party, I mean a judge could make a decision on at a later date. But during like the claim, the insurance company dictates it. So you basically have to do what they're asking. Otherwise, they can stop your claim for you not filling out the repeated form. So you could take a stand and say, I'm not going to fill this form out again. They deny you for that. You then appeal it, get denied. You go to court and a judge says, yeah, they were right. You have to fill out this form. Then, you would lose, right? So it's a lot. You don't want to go to if you're going to court to fight something, you want to be fighting over whether you are disabled or not over these other issues, because you can be determined to be disabled, but if you didn't fill out forms that you're required to fill out, they're allowed to stop your payments just for that. So you really need to avoid that. And unfortunately, it just means you have to fill out these forms. Unfortunately. Again, I don't know your exact situation. There could be situations where it is excessive and maybe you could take a stand, but I would really caution you against that. I'd caution anybody about taking that stance because it's so hard to know if you, in fact, do have a situation where it is excessive. And in the meantime, they could cut off your benefits while you're fighting them about it. So there's a lot. Unfortunately, you often just have to do the forms. Eventually, these forms do, even in the worst case scenarios, they don't send these forms repeatedly forever. Most often when you're getting these forms a lot, it's when you're in some critical juncture of your claim where they're monitoring closely. That is typically when you're going to see a lot of forms. But once things have simmered down and they're more comfortable with your situation, that is when the forms become much more infrequent. So I would say you cannot refuse to fill out these forms. I mean, you can, but it would be highly advisable not to. All right. There's the last question here that says, what actually happens at the 2-year mark of LTD? Can insurers stop paying, force a return to work, or change the definition of disability? And how should someone prepare for that transition? So, yes, at the 2-year mark, assuming your policy has a 2-year change of definition, the definition of disability will change. It will become harder for you to prove that you meet the criteria for disability benefits. And yes, they can force a return. They can force a return to work by just not paying you. So you don't have to return to work, but they will just stop paying you. So what will happen at the 2-year mark is they will assess your case. They will make a judgment call on whether they may agree that you can't do your regular occupation, but that you should be able to do work that would fall under the any occupation. So it's a more generous definition for them. They feel like you should be able to do some other work at a level that would disqualify you from LTD. And if they take that position, that's the view they're going to take, they just stop paying you. So some people call that forcing me back to work. It is, in a sense, forcing you back to work. They may also be more direct in saying that they are coordinating a return to work, sending things to your employer, setting it all up. So in that case, it even is more like they're forcing you back to work because they've set up a whole process, and you would need to reject. And then they might wait for you to reject the return to work, and then they would, stop. Often though, like, they're not engineering a return to work because the whole idea is when you're at the change of definition, you can't go back to your old job. So usually what they're not arranging you to go back to your old employer, they're more trying to establish that there's other work out there that you could do. So just keep that in mind. It's usually not engineering you to go back to your old employer. It's they're showing that there's other jobs out there that you could do. And they will usually have, it's not unusual for them to pay for vocational experts and return to work experts to come up with potential jobs that you could do based on your abilities. All right. Okay. The last part of that was, how do people prepare for that transition? I think the way you prepare is continue to go to your doctor and understand what the real criteria is in your situation. Every policy is different because it says, like, it will always say, like, can you do any other occupation? But that is a nuanced definition. It would be very important to understand in your situation, what would any other occupation look like? Like, what is the income threshold? That is what can be very different from policy to policy. What qualifies as any other job will still have to meet a certain income. So, for example, with some policies, maybe that income threshold is like 30,000. If you have the capability of earning $30,000 or more a year, you are no longer disabled under the any occupation. But other people who had a higher income pre-disability, maybe theirs is, if you can't, you'll be considered totally disabled from any occupation as long as you don't have the capacity to earn 60,000 or 70,000. So it can really matter case to case, depending on the wording of your policy and how much you earned before, whether you're able to meet this definition of any occupation or not. So it's important to understand that, because doctors won't understand that. Doctors won't really get that at all. They'll think that the only way you can get any occupation is if you literally can't do any occupation, which is never correct. That's rarely ever correct with long-term disability. Even with CPP disability, it's not correct. But that your doctor may be under kind of mistaken understanding on that. All right. Let's move on. Okay, let's dive back in. We got another question that came in while I'm chatting here. This one says, my current disability tax credit expires in 2026. When should I reapply so that I may have the best chance to continue with it? Okay, Bruck, I would say if it expires at the end of 2026, if I were you, I would be getting it in and submitted to them during 2026. So by the middle of next year, you'd want to have this into them, give them plenty of time to process it and approve you. You want to be like, the only reason you could start it, like, there's no reason you couldn't start it now, as long as the doctor can reliably state that your condition is going to be the same. Like, what you don't want to do is submit it early and your doctor says, oh, we're going to reevaluate in a few months. And then it's like, well, you just waste, like, as long as a doctor is saying this is the situation, it's not going to change, then you could put the application at any time. If the doctor can like say what your ability is going to be over the next 5 years, that's how they would do it. But if your doctor says something like, well, he's doing some things and maybe things will improve and we're going to reevaluate later in the fall, like, that's no good. You'd have been better off waiting till the fall and have the doctor write it then. But if you think your doctor is just going to say the same thing they did before, then there's no reason not to just start putting it together sooner rather than later and getting it in. Certainly apply in 2026. You don't need to wait till the last minute. All right, let's go back to questions. Midnight says, thank you for answering. Yeah, no problem. No problem. You keep those questions coming. And like other people did, you can submit them ahead of time by sending them to support@resolutelegal.ca. And Jen, who is the head of our intake team, she just gets the questions to me, and then I get them prepared here for today. Okay, let's move on. Here we go. This one comes up a lot. Let me get rid of the... Yeah, this one comes up a lot. So let's talk about unions. This one says, what can an employee do if their union has dragged out a grievance since 2022 and the appeal since 2023, and they're stuck on a medical leave because the workplace issues aren't resolved? Yeah, this is like, there's good and bad with dealing with unions. And one of the bad things is you don't have a lot of control over it. The union handles the grievance. It's really the union's grievance, not your personal grievance. That's kind of how it's viewed. And there's not a whole lot you can do. I'll be honest with you. They control the grievance. So when you're in a union, you don't have a personal right to do anything. You just have a right to present your issue to the grievance and if the union wants to take their grievance forward, they can do it on your behalf. Now, unions do have a duty for fair representation, which means they have to act in good faith. They have to communicate with you. They have to move the grievance forward through the normal process and avoid unreasonable delays. So a grievance stalled for 2 years, that might be a breach of, I can't say specifically, but certainly what you're presenting is something stalled for this long could be seen in some views as maybe they are not moving things along properly. But I don't know all the details. It's very possible that this is the fastest it could go. There's other issues, and this is a normal course. So it's impossible for me really to say. I just know I can understand from your point of view why you'd be so frustrated with this. Now, what you can do is just document everything, and the only recourse people have is to go to the labor board of your province and put a complaint in against your own union. Now, I rarely recommend people do that because of how ineffective it is, and the unions have such a low bar to get over to show that they're giving you reasonable representation that it's almost impossible to win these, at least in my view. So it's not that I'm urging you to do that, but that is the only thing you can do is file complaints with the labor board about your own union. So if like the kind of situation where you would be successful maybe putting in a complaint against your union, and again, how far does that get you? It just means that they have to restart the grievance or something like. But if the union has secretly just sort of swept this under the rug and have decided not to pursue the grievance and haven't told you, that could be seen as a violation of their duties, the union duties. But again, what do you really get by filing a complaint against the union? It's not really my area, dealing with unions and things, to be honest. But I can just tell you, the labor board is the only accountability mechanism you have for unions if you're a union member, other than just going to the union itself and trying to go up, talk to different people, see what's going on. But it is definitely very frustrating because you do not have control over the process. All right, let's go to this next one here. This one we kind of answered, but we'll do it again. If LTD switches to any occupation at 2 years and CPP disability was denied, can the insurer use that to force a return to work? What should a person expect after a CPP denial? So what I would say is after a CPP disability denial, I would keep appealing it. Not sure where your denial happened or at what phase, but CPP is meant to be appealed. I've made a career out of getting people approved at the tribunal. If those people hadn't have kept appealing, they would not have been successful. In many cases, if they hadn't have hired us, they also would not have been successful because they were not presenting an effective claim. So What I would say to you is that you should, after a CPP denial, you should be expecting to keep appealing. Long-term disability does not, like a CPP denial does not prove that someone can work. CPP disability, generally speaking, is a much stricter definition of disability than long-term disability. So it's normal that someone would qualify for long-term disability from any occupation after the change of definition. And it's quite conceivable that someone would meet that and not meet the criteria for CPP disability. Okay. Remember before I was saying that it's very much focused on income level. So if you earned 100,000, I'll just use 100,000 because it's easy math. If you earned $100,000 a year and your LTD is approved, most likely at the any occupation, you would be considered disabled for any occupation LTD as long as you weren't capable earning $60,000 or more a year. So if you were only capable of earning $40,000 a year, you still would qualify for long-term disability, at least for a top-up payment. Now, CPP disability, the income threshold for CPP disability for gainful income is $20,000 in change. So you can see the difference there. To qualify for CPP disability, you must prove that you are incapable of earning on a regular, like working on a regular basis and earning at least $20,000 a year. That is a far cry from like $60,000, right? So you could be not capable of working 60,000 and therefore you qualify for long-term disability, but you are capable of earning 20 and therefore you don't qualify for CPP. So one is not going to affect the other. It's not going to be a situation where the LTD automatically cuts you off or anything like that. I would still focus on trying to appeal the LTD, the CPP. If you're on an approved long-term disability, typically they are going to get you support to do these appeals. They often have deals with different disability advocacy organizations and companies who the insurer will pay to represent you. It's in the insurer's best interest to get you approved for CPP disability because it will often reduce what they're paying you. So it's in their financial interest to make that happen. That's what I would explore if I were you, and maybe you already are, but that's what you should explore to try to get representation to keep appealing the CPP disability. All right. So you might not have to expect anything. The only thing you might expect from the insurer is they might want you to keep appealing. Often they do. Sometimes you're required to keep appealing by the wording of your policy. So that is just something to keep in mind and look for. All right. Let's move on to another one. Okay. Oh, we got a question here. I'll go to that first. It's Midnight Blue again. Hey, welcome. More questions. Do you help submit CPP disability applications or only appeals hearings? How much medical info does your doctor have to give Service Canada? And is your doctor evaluating your ability to work your current job? Okay, that's a good question. So first of all, we do represent people in CPP disability applications. We only do that for a flat rate, and I won't talk rates here on the air, but you can contact us to learn what they are. They change, and I'm not always up to date, so I don't like quoting things because I often get it wrong, and people will see the video and they'll come. My support team will be all over my back. So I'm not going to say exactly what it is, but you can call in and find out, like, what do we charge to represent people? We only do it on a fixed fee. We do some appeals on contingency fee, only get paid if you win. Okay. So how much medical info does your doctor have to give? The minimum they have to give is to fill out the form. There's a medical report form that your doctor has to fill out. That's the minimum. What I would recommend, though, is that the doctor give a copy, your family doctor give a copy of their medical file. Going back, how far you go back really depends on the case, but once you figure out when your minimum qualifying period is, you want to go back several years before that, depending on like how long you were struggling in the workforce and that kind of thing. So it's always a question of how far to go back, but you want to go back far enough in the records to make sure you're before the end of the minimum qualifying period, and also far enough to show the struggle over time with your disability, how it affected work. The more info you have, the better for historical info. Now, the last question here is, and is your doctor evaluating your workability at your current job? So CPP disability, you never want to focus on your current job. That is a trap, and they will pounce on that. So your doctor should be evaluating your ability to do any type of work. Okay, even part-time work that you could, even part-time work that where you could conceivably earn 20,000 a year doing it on a regular basis. So it is not about your current job. You don't want your doctor saying anything about can't do current job. CPP won't care. They will just immediately say that is not the test. It's any work, including part-time work that you can do on a regular basis, earning $20,000 a year. So the form that your doctor fills out for Service Canada, it does have questions in there about, can the person work now? Have you recommended they go off work? Ideally, your doctor will say, yes, I've recommended they go off work. No, they can't work right now. It'll have things like, is this, do you expect them to return to work soon? If they click no, that's even better. So there's these types of questions on the form that they fill out. And that's kind of what the insurer will go by. Now, even if your doctor fills out the form in your favor, sometimes they will still deny your claim, believe it or not. And that's why it's helpful to have more medical information, the better. The more medical information, the better. Okay. Let's before I finish more questions, let's switch gears. I know some people might be here for the other topic I was going to cover tonight. This one is working part-time. We're all on LTD. We've touched on this a little bit, I guess. Let's dive back in here. Okay. Let me find my notes. All righty. So this was actually one of the questions a person was talking about doing. They were saying doing part-time work, doing their own crafts and art sales and that type of thing. Part-time work is not automatically disqualifying. That's very important to know up front. In fact, it's quite possible to be working part-time and receive long-term disability benefits and still qualify for CPP. All it matters is the amount and whether the part-time work you're doing demonstrates, like if the part-time work you're doing demonstrates that you have residual earning capacity, that is where the problem starts. So like the more regular you're able to do the part-time work, the more it will be evidence that maybe you could work more and earn more. That is the only danger with this. That's why like crafts and different art things that you're doing kind of weird hours and whenever you can. And like that stuff is very difficult to show that you would have a capacity. If you're showing up to a workplace and you're regularly working couple days a week, the same days, the same time, like that establishes a pattern where you're demonstrating you're reliable and might be able to work on a regular basis. Especially with CPP disability, you only have to have the capacity to earn $20,000 a year. Now that can be a lot of money if you can only work a very limited amount, but you can get there, right? You can work part-time and earn $20,000. So that is something you have to keep in mind, especially if you come from a professional background. Where I see people get into trouble is when they have a professional background, they're only working very limited, but they're getting paid a lot. Like I've represented like insurance claim representatives actually who are off on disability, but got a part-time job doing some claim reviews for an insurance company or whatever. And next thing you know, they made $50,000 in a year and now they're freaking out. So that is the situation where you can get yourself into trouble. Now, I encourage part-time work because most people do not want to stay on long-term disability their whole life. But they're also very worried because What if they start to try part-time work and the insurance company pulls the rug out from under them and stops benefits? This is why I would tell you it is very important if you're considering part-time work to discuss it with your doctor, then approach the insurance company and say that you would like to try some part-time work, even if it's volunteer work, but let the insurance company know what you're planning. That will minimize the chances that the rug will get pulled out from under you. If the insurance company, if they discover things, they're more likely to see it through a nefarious kind of view. If they discover that you're working part-time and you didn't tell them, and they're more likely to give you the least charitable view of it. And so the more you're upfront with them, the better this will usually go every time. The insurers will, when they see you're working part-time, they will want to figure out, okay, they're doing this part-time work. Are they capable of full-time work or not? Again, your doctor can help with that. Sometimes the nature of the work itself will be obvious that you are not. But where you will get into trouble is, for example, if the part-time work is with a family member's business, that's a problem, because now the insurer is going to be worried whenever you're into a family member or a family business, all of a sudden, maybe you're not reporting all the income. It now becomes a more difficult situation where you might not be reporting all the work. Maybe they're paying you under the table. Maybe this is where family businesses will be a big red flag. So people say to me, I'm going to do some part-time work. My husband's doing this. And I'm like, whoa. You're going to start doing part-time work in a family business. That is red flag city for the insurance company. So you have to go into that very carefully, knowing that they're going to be very suspicious, and you better have the best bookkeeping and accounting in the world to show that you are not doing more work than you're doing. And it's very hard. Even then, they're still going to be worried, depending on the type of business. The other part might be if the income just seems inconsistent with disability. I've had situations where real estate agents, someone on disability got a real estate license, and what they would do is they got a real estate license so that a family member could give them a transaction, who maybe a family member who was maybe in construction or did everything, would just give them a couple transactions a year, and they would have this big spike in income. Now, again, you got to wonder what is really going on here. Why is this not really a real business? It almost seems like the family member is doing this as a way to gift you money kind of thing. But that can cause a problem, because maybe you do this big thing and now you've got this check coming in for $10,000, $20,000 from doing these one or two transactions. And you're saying, well, look, I can't do them all the time, but this was for a family member and I did. Just know that kind of thing is going to raise huge red flags and problems. That is not going to be something you're going to be able to do and keep your LTD for the most part. If you're proving that you can do these transactions for a lot of money, even if they're coming through a family member, the insurer is going to be very suspicious. So sometimes the amount of money, even if it's only smaller transactions, but they're high money, can be a big problem. The other part of this is some of these return to works don't go well and you can just crash and burn. And that is very unfortunate. You really should try to avoid that, obviously, but some people, they really want to try to make it work. It's very important with any return to work that you're doing, get it well documented and schedule regular follow-ups with your doctor to have it recorded on how you're doing. If they have to increase your medications, there are things that may indicate that things are getting worse or you're struggling, like increasing medications, reporting more symptoms. You need objective ways to prove this. And the best way is through medical records showing after you started working, you're reporting more symptoms. They had to raise the thing. And the doctor may decide at some point that the symptoms have gotten too much worse. They don't want to keep raising your medications. And so they're going to take you back off work and have things simmer down. So the other thing is to keep in mind with part-time work is just look and see what your policy allows. Some policies are worded in a way that they anticipate part-time work. They have things called partial disability clauses. So that's not only just total disability. Some policies have partial disability, residual disability. You want to read through your policy and see what it allows in terms of when you're able to work. A common trend is for policies to have these rehabilitation clauses. The rehabilitation clauses, they give the insurer a broad latitude to allow you to work and still get your LTD. So, for example, if you're someone who wants to try a return to work, you could, if your insurance company has one of these rehabilitation clauses, you could ask them, like, I'd like to go use that rehabilitation clause to do an attempt to return to work. Please get a return to work coordinator. What they'll allow you to do is continue to get your LTD benefits while you're also getting money from work, as long as the total doesn't equal more than 100% of your pre-disability income, then you can get both. That is the way to go quite often in these, is to use the rehabilitation provision under the policy. It is odd. Like I did a consultation this week with someone who people will just pay me to do a consultation about their situation. This person had a policy, like they were getting a severance payment and they wanted to know, I'm on LTD. If I get this severance payment, is the LTD just going to claw it all back? And surprisingly, the answer was no. It's rare to see it, but they had an LTD policy that did not claw back severance payments, any type of severance payments. So I was like, no, actually, you get to keep the whole thing. So you will often see people just assume that all LTD policies claw back severance payments, like severance from your employer. So this was someone off on disability, and their employer terminated. They've been off. They're on LTD. The employer terminated their job for frustration of contract and wanted to pay them out as severance. And they wanted me to review the whole thing, make sure that the release they had to sign was not going to cause their LTD claim to have problems. They wanted to know, would they keep the money? Would it all go to LTD? And so that's kind of what we discussed. And I looked at their policy. I went over it many times because you don't want to get this wrong as a lawyer, honestly. So I went over it many times, and I was very confident. In fact, I was certain that the policy they gave me would not allow offset of the severance. The other thing, and I've done a number of these, like over this year, I've probably done 4 or 5 of these consultations with this exact situation. Somebody on LTD being offered severance. They want to know, and a release. They want to know, will it affect? And in at least 3 of the cases, there was real issues with the release that they were the employer wants you to sign a release. And sometimes the wording of that release is such that it would, at least on its face, try to prevent you, if your LTD ever got cut off, this release would say that you're not allowed to sue the LTD insurer if your LTD ever got cut off in the future. So in 2 of those cases, I gave like recommendations for them to get the release amended to fix that, and they did. To the employer's credit, they agreed and they fixed it. And it actually was a mass layoff situation. And I had another person call us, and it was funny. It was the same employer, and this person had called in, and they're like, oh, this is the release. And I was like, okay, the release they're giving this person is the one with my amendment in it. So we told them, look, you don't have to pay. This release has already been amended. But the one I reviewed this week, the actual wording of the release was fine. The release was worded that it only restricted you from suing any claims against the employer or the insurance company that were claims that you could make up to the date of signing the release. So I told the person, look, as long as your LTD is approved right now and you have no claim against the insurer, you are free to sign this. If 2 weeks from now, after you sign it, the insurer cuts you off, this release would not prevent you from suing them. But if you had something right now, you're cut off right now, you would not want to sign this release because it is saying that you would not be able to sue the insurer. Now, it's debatable whether an employer's release from your employment could prevent you from suing an insurer. Even if it says you can't, that is still an area that the law might say that is something the employer can't prevent. But I would rather not be in that fight. If I were you, I would not want to have to fight that. I would just try to get that wording fixed in releases. All right. Let's go through the last few questions here. We're getting near the end. So let's go back to questions. Okay, here's one. Okay, let's find it here. Sorry, I'm just trying to find my notes and where it matches up. So there's the grievance. No, here we go. Okay, there we go. I found it. All right. Let's go on here. So this one says, I'm on LTD for anxiety. Workplace was toxic. As I start occupational therapy and plan for return to work, can I request accommodation to return to a different role department instead of the same environment? This is a great question. This comes up a lot. A lot of people want to know this. So I want to say that in theory, there's the theory and then there's the reality. So in theory, workplace accommodation it can include things like the work environment. It often includes things like reduced hours, modified duties. It can include other things like a different role or department. It can include those things. Okay. In theory, it's the employer's duty to explore all reasonable options. That is what they have. That's their duty. So they can't just dismiss this out of hand. They would need to give it some consideration and look at it whether this would be a reasonable option. If that was a legitimate grounds for accommodation, a different department or things like that, that's something they would at least have to consider. But employers are not required to create a new job or move you to different departments. It could be that it is often hard to prove that this is a toxic environment, especially if the employer says they've taken steps to fix it. It can put you in a spot where it's very hard for you to prove that it's a toxic environment, and whether putting you back in that environment would be detrimental. Now, it's most often I tell people it's very impractical to be able to get that goal, that to get an accommodation that would allow you to not be put back in that department. The human rights commissions, they give a lot of latitude to employers. The employers have to they have to explore all reasonable options, but they don't like to dictate to employers that you have to put them here, you have to move them here, you have to give them a different manager. They don't like to micromanage like that. So most often that is not going to come out in your favor. Now, if you're working with an occupational therapist, you can bring this up to them, and it's possible the occupational therapist could recommend a different environment based on other factors if it's reasonable, not necessarily just like a toxic work environment. That is going to be a very hard thing for people to talk about and acknowledge, because there is a subjectivity to it. But if there were things like about the job itself, like the workload demands and these types of things that aren't appropriate for your disability and your limitations, that could be a reason why a different environment or department could be recommended. But it is a very tough thing to do. Very tough thing to do. So, I mean, it's possible, but it's very hard. The other problem you get into with this is the more you focus on the toxic work environment, the more the LTD will look at this as a work problem and not an LTD situation. This is another thing just to keep in mind. Now, if in fact it is a toxic work environment, then what you would do is, like, if you got placed back into they didn't accept that as an accommodation, you got placed back into the toxic work environment, it's possible that you could then file a human rights complaint if they did not take the proper steps to fix the toxic environment. But again, toxic environment is very subjective, and it may be hard for you to prove that the environment is toxic from the point of view of like occupational health and safety. Okay. It may not, there may be personality clashes and things that you cannot work in that environment, but it might not rise to the level that an occupational health and safety would deem it to be a toxic workplace. Very difficult, very difficult. I feel bad for people who have to kind of navigate this because it's very hard, and I don't have good answers, unfortunately. Okay, next one here. So this comes up. This is a question. This question actually came from the forum, and it says, insurer wants 100+ pages of medical records again. Doctor gave them to me to send. How should I send them so I have proof? Is tracked mail enough? Yes. Tracked mail is, we use Canada Post Express Post or Priority, Canada Post Priority with tracking and signature. That's what we use because it's the cheapest, it's reliable enough, and in fact, it's great because it's got a higher deliverability sometimes than a lot of the couriers, because Canada Post Express Post can often get delivered to mailbox, like PO boxes, whereas couriers cannot deliver to a PO box, but Canada Post Express Post can often be delivered to PO boxes. Okay, that's like a hack in the system. So what I would do is I would recommend using Canada Post Express Post and just choose to pay for tracking and a signature. Then you have proof that it was sent. It doesn't cost that much more to add that on, but that's what I would recommend. Oftentimes it's better just to send the pages themselves because it's hard for people to scan. You can't take 100 pages with your phone and take pictures. That's just not going to be feasible. It's not practical. And unless you have a scanning app, then it's just completely not doable. You can't send somebody like 100 photographs of pages. It's not practical for people to use that. The sheer size and volume of the data that wouldn't work. So you need to be able to scan that. And if you can't scan it and send it and upload it somehow to some portal, then you would just want to send the pages. Probably the simplest thing to do. Ideally, you'd want to keep a copy yourself if you can afford to do that and go somewhere and get a copy of this. So you could take that and go to a Staples or somewhere and get it scanned and copied if you want to do that. Then have your own electronic copy or get your own paper copy, but whatever. If you're not too concerned about that, just send it off with like I said, with the Express Post tracking and signature. All right, last question. First meeting with LTD rehab consultant, what to expect? And should I share concerns about returning to my old department due to comments made while I've been on leave? Ooh, another one. I wonder if this is the same person. Okay, what's the best way to answer this? So the first meeting with a rehab consultant is usually going to be very much information gathering. They're going to ask you about your condition, your treatment, your progress. That's mostly them just getting to know you and getting information. Now, like I said before, generally speaking, you have to be very cautious about workplace issues. Okay. You don't want to frame workplace issues as the main reason for your disability leave, as that completely undermines your LTD claim and can result in you giving the evidence necessary to not pay you LTD benefits. Even if you feel like that might be the case, it might not be objectively true. So you can be really shooting yourself in the foot here, because an objective person would look at this and say, look, obviously these inflame the situation, but you have these problems regardless. So You don't want to like hand the insurer on a silver platter a way to deny your claim by framing the whole thing as workplace issues and nothing to do with disability, or that you wouldn't be disabled without these workplace issues. That is a real problem that you can create for yourself. So you have to be very careful about that. All right. Now, what you can do is frame it like, what's the best way to describe this? You can frame it that your medical condition is like the reason you're off, but returning to the same department there may not support you, right? There's added stressors and things in there. So you can say to the return to work person, like, there's going to be stressors and things, and there's trust issues because people there have made comments about me while I'm gone that are going to really cause stress and hamper the return to work. And you can say, like, because of that, like maybe a different work environment would be better. So this is similar to the other question we talked about, how it's very hard for you to make a different work environment or a different department or a different manager as part of an accommodation. That's a very high bar to get over, to insist on that as being an accommodation, but it is something you can at least introduce. The best way to introduce it is through a rehab consultant and have their view on it to see if there's something that can be done. Rehab consultants are really focused on, like, what are your current limits in terms of your functioning? What kind of tolerance do you have, like ability to do like mental and physical tasks, whether a gradual return to work is feasible, and what are the environmental restrictions in your workplace that might prevent you from working? And yes, like relationships with coworkers can be a factor. And so, like, they may come to a conclusion that you need a low stress environment to be able to be successful, and that might mean shifting you to a different department. That's something that's the way that this might get fit under as a medical accommodation. But again, it is very hard to enforce that if the employer does not want to do it. It has to be focused on, like, you need to be in a quieter, less stressful environment. It can't be that she doesn't want to go back and work with Susie, who's toxic and has been talking shit about her the whole time she's gone. Like, that is where it falls down, because the employer will disagree. Susie's had, they've addressed it with Susie, the manager, and she's not, like, you're just into this thing where it's going to be impossible to approve things. And again, like, you don't have control to dictate where you work and the department and the managers. Like, you don't have the ability to do that, and it is near impossible to have a workplace accommodation that you don't work with a certain manager. That is not the way accommodations are functioning, and I've never known that type of accommodation to be successful. Okay, folks, we are coming up on the end here. I appreciate all you that have shown up and stuck with me here to the end. Please send your questions in again for next week. If I didn't answer your question well enough, you can ship it back next week with some refinements. Just send them to support@resolutelegal.ca. Or you can, that's probably the best way to send them in, support@resolutelegal.ca. Just say it's a question for the YouTube. You can also reply to the email. So if you're on our email list, you will get an email every week saying that. That's probably the best way to do it, actually. If you just reply to the email that comes out every week saying this week's our topics or whatever, you can reply to that email with your questions as well, or just reply to a previous week's email. That will go to the same people. That will go to Jen, who's managing this, and she will be able to get your questions onto me. That's all for tonight. I wish you guys all the best, and I will see you back here next Tuesday. Take care.